One of those two. Good morning. Welcome again to the Nags Head regular session Board of Commissioners meeting. It's Wednesday, August the 7th. We're going to call our meeting to order, and we're going to start with a moment of silent meditation. Amen. If you'll join us in the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Our first item this morning is the adoption of the agenda. I would like to ask us to take number 10 off the consent agenda, please.
Move to adopt as amended.
Second.
Further discussion? All in favor of the motion, please signify by saying aye.
Aye.
All those opposed, like sign. The motion passes unanimously. This is the time of the morning that we set aside for audience response. Any of the public that wishes to come, please, if you'll come to the podium and give us your name and address, and we'll be glad to hear your comments. Oh, give them just a second.
A second is right. Gary Oliver, the Outer Banks Fishing Pier. I'm here to talk about the beach access at Isabella Street, which is like all the rest of them this time of year. They're all packed and people parked on the side of the road, and that's just the way it is. Down there at Isabella Street, being next to the pier, it fills up first, and then the parking lot at the pier fills up. I don't police the parking lot. I tried at one time, and normally the people I said had to move were going up to the pier, so I gave up, and they use the restrooms, and we welcome people down there. It's just the way it is, and then when that fills up, then they go across the street and park on the side of the road. And there have been some issues with it. A few people have complained, and the problem has been people coming out of South Creek Acres at Isabella Street access, people parking right next to the road. I met with the chief of police yesterday down there, and Mayor Oakes came down, and we looked at it, and we agreed that the best solution would be to have a buffer on each side of Isabella Street, 40 or 50 feet, and so a line of view could be had like they do at the rest of the beach accesses. And I think that's the answer to the problem, and I would hope that the board would agree to that. I think it's a fine thing to do. And the chief of police does a great job with all the beach accesses. He says there are a lot of problems up and down the beach, but people have to get to the beach, and they are going to park on the side of the road, and we just have to put up with it for about 3 months. Anyway, thank you very much for your time.
Thank you, Mr. Oliver. Ms. Upton.
Good morning. I'm Margaret Suppler, 8200 Old Oregon Inlet Road. First of all, I'd like to just say I support Mr. Oliver's position as well. But this morning I'm here to just to make a comment about some grapevine information that has come my way about a proposed Harris Teeter at the old Penguin Isle site. My concerns are, number one, I think public safety would be a tremendous issue there. Anyone who ever has been to that site understands the challenges of ingress and egress from that site. I don't think that traffic light's going to solve that situation. Secondly, any of us who've been through any significant stormwater storms also realizes that that area is highly prone to flooding, and with the new stormwater impact, I don't feel that they'll be able to manage their own stormwater runoff. And lastly, if the figures I saw last night on the internet, and I know you can believe everything you see on the internet, so I know it's true, indicates that in Dare County there's 3.5 stores per 10,000 population, and statewide there's 2.03 stores per 10,000 population. So if those numbers are indeed correct, then I believe we have a significant amount of stores to handle our population here. And that's really all I have to say, and I thank you for your time this morning.
Thank you, ma'am.
Good morning, Mayor and Commissioners. I'm Marvin Demers, 8819 South Old Oregon Inlet Road. As you can tell from my address, I live right close to the Outer Banks Pier, and I can just say from experience, I observed the parking up and down east and west side of the highway down there. I don't see that as a traffic issue. I haven't seen any near accidents or seen any traffic blockage. People go down South Old Oregon Inlet until they find out there's no room in the pier parking lot or at Isabella Street to park. They go a little further down, turn around, come back up until they find a space, normally by the side of the road. So we see the cars parked up even north of where we live, but it hasn't been an issue, and I think the proposed solution about a buffer zone to ensure safety is a good idea. I also think it would be great to implement one of the recommendations from the Parks and Recreation Committee plan, the plan that was developed by that committee, and that was to make sure we have a crosswalk in the heavily trafficked areas on South Old Oregon Inlet, and that is the most heavily trafficked area. So I would like to see you consider that recommendation. Thank you.
Thank you, sir. Anybody else that would like to speak to the board this morning? Seeing none, we're going to close our public comment period and move on to recognition. Good morning, Ralph.
Good morning, Mayor. How are you?
Good, sir.
Mayor, Commissioners, this morning is my privilege to introduce you to Buddy Beecham again for his 5 years of recognition. Buddy came to the town on June in 2008. Since Buddy's been here, Buddy has been certified with his well license. He's also licensed by the Rural Water Association of North Carolina for fecal coliform. He's here this morning with his lovely wife Melanie, and I was told Buddy's two passions are kind of like mine. He loves to travel and he loves to spend time with his grandchildren. So, this is Buddy. Thank you.
Buddy, if you'll come up, we've got a very nice cross pin for you. We appreciate your 5 years of service, and thank you, sir. Look forward to many more. Thank you.
Thank you.
Good luck.
Thanks, sir.
We've also got a very special bit of recognition this morning, not for one of our employees. Good morning, Kevin.
Almost. Good morning, Mayor, Commissioners. Here before you today to recognize two great people. Andy and Lovey McCann are here in the back row. I'd like to have them come forward if you would, please, folks. As you know, on July 4th, the town of Nags Head, Outer Banks Visitors Bureau, and Nags Head Fishing Pier sponsored the July 4th fireworks. And it was a fantastic event attended by thousands of people. The most difficult component of a fireworks display is making a proper site selection. And Nags Head Pier has stepped up regularly to provide that site to ensure safety of the crowd and a wonderful display. And we really appreciate that event every year. Mr. and Mrs. McCann, on behalf of the Board of Commissioners and citizens, the town of Nags Head wishes to express its sincere gratitude to you for your generosity and continual support of the Nags Head fireworks. We hereby present you this Ray Matthews photograph of the 2013 fireworks display, recognizing your contribution and a job well done. Thank you very much.
Thank you. And we'll try to keep from blowing up your pier. Thanks again. Love you.
Thank y'all very much. Best one yet, y'all.
Thank you. As good as I love fireworks, I appreciate the place to have it. Thank you very much. Thank you. Yeah, it's wonderful. Thank you.
Next item this morning is the consent agenda.
Didn't we, I'm sorry, didn't we, what is it on the consent agenda that did
We took out number 10, the traffic control map amendment.
Move to adopt the consent agenda as amended.
Second?
We have a motion and a second. Is there further discussion? All those in favor signify by saying aye.
Aye.
Aye. All those opposed, like sign. We're going to put number 10, right under new business after committee reports, okay? Next item is a public hearing. We did have 2 public hearings scheduled for this morning, but one was withdrawn by the applicant. The second one is a public hearing to consider adoption of a zoning ordinance text amendment to Town Code Section 48-325E, outdoor lighting. Good morning, Ms. Violet.
Mr. Mayor, at this time, we'll begin the public hearing to consider that zoning ordinance text amendment. And this is one designed to allow light fixtures, including signs, associated with hotel uses within the CR district to exceed 35 feet in height. And we'll begin with the staff's analysis presented by Kelly Wyatt.
Good morning, Mayor and Commissioners. Following the variance request made by the Nags Head Inn to replace storm damage signage above the 35-foot height limit for light fixtures, the board requested that planning staff revisit this town code section. Specifically, it reads, "No light fixture, including signs, shall exceed 35 feet in height, except as specified in section 48.325 subsection F and 48.328 subsections E6. And those 2 sections pertain to FAA regulations and lighting of outdoor recreational facilities. With the maximum overall height of hotels in the CR district being 60 feet, staff felt like the limitation on lit signage being 35 feet may not be suitable. So planning staff has provided 3 ordinance revisions to Town Code Section 48.325E general provisions for your review. Option A would allow lit signs to a height of 55 feet in the CR district only and for hotels only. Option B would allow lit signs to a height of 55 feet in the CR district only, but for all uses within the CR. And option C would allow lit signs, regardless of height, to be repaired or replaced so long as there is no increase in the degree of nonconformity. And this would include the height of the sign or the square footage of the sign, and this would be permitted townwide. We have 2 structures within the town that this ordinance would affect, and that's Nags Head Inn, who did request the variance, and the variance was granted, and then additionally, Comfort Inn South. Based upon evidence that was presented at the Board of Adjustment variance hearing, there could be a benefit in raising the lighted signage height on hotels to avoid light shining onto adjacent residential properties. And where that's coming from is for a single-family dwelling or duplex, the maximum height is 35 feet. You can go to 42 with the roof pitch. But if you have a 60-foot hotel with lit signage, it could be reasonable to think that the light shining off of that sign could be hitting right around that 35 foot for the adjacent residential. The Planning Board heard this issue at their July 16th, 2013 meeting and voted unanimously to recommend adoption of zoning ordinance text amendment option number C. That would allow nonconforming signage to remain so long as the nonconformity was not increased, but it would not allow any new signage above 35. Happy to answer any questions on this.
Does the board have any questions for Ms. Wyatt? None?
Move to adopt as presented option C.
still in the public hearing portion. Let's see if
I'm
there's
sorry.
Probably will let the public speak. Just-
anyone
guess- yeah,
who's
I guess
eager
we
to
should.
comment on this item. Thank you, Ms. Wyatt.
Thank you.
Does anybody from the public wish to comment on this matter? Or from the planning board? Mr. Demers?
Good morning again. The planning board considered this not at length, but definitely in depth, and felt that this is one of those situations where we have a good town code of ordinances, but there are always little things that pop up here and there that just can be improved. And we felt that this kind of met the consideration of maintaining the character of the town and at the same time not putting undue restrictions on the townspeople or the town businesses, and simply to repair and replace something that's been in existence for many years seemed to make a great deal of sense. So that's why we recommended option C.
Any questions? Thank you very much, sir. Would anyone else from the public like to comment on this proposed text amendment? If not, does the board wish to receive any further information before it begins deliberations? All right, if not, we'll conclude the public hearing on this proposed zoning ordinance text amendment, and the board may begin its deliberations. I would point out that if the board is going to take action, you need to specify which of those various options you're going to take action on.
Move to adopt with option C. Sorry, I got ahead of myself here.
It's okay.
Second.
I appreciate the effort to speed up the meeting, sir. Further discussion? All those in favor of the motion, please signify by saying aye. 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 All those opposed, like sign. Motion passes unanimously. Next item is G, reports and recommendations from the Planning Board and the Planning Development Director. Update on town projects.
I'm going to try to fill in here as best as I can. If there's anything in particular that you would like more information on, just let me know. I'll hit each one individually. Some of these items, Air Planner Angela Welsh has more knowledge on, so may need to pull her up here for some of these. The first item, the fill, stormwater, and runoff management ordinance that the Planning Board and planning staff has been working on for quite a while, sort of coming to a close. We're putting the draft together, and we intend to get that to the Planning Board for their review at their August 20th, 2013 meeting. The Planning Department is hosting another intern this year. We anticipate that the intern would probably be most involved with the upcoming pedestrian plan that we're working on. One thing that Angela's much more versed in is the comprehensive pedestrian master plan. As you can see here, the town was formally notified that the grant application to NCDOT was fully funded. The town's going to need to execute a municipal agreement with NCDOT, establish a steering committee, and select a pre-qualified consultant to develop the plan. Town staff has been working with the board-appointed committee on the Soundside Boardwalk. It's really just in the beginning phases at this stage. Most of the property owners have been contacted and do seem to be on board. I believe there's 2 property owners that we're still in discussions with. Once that's finalized, our contractor, George Wood, is going to begin doing the environmental analysis and the backup work for that. Lee Leidy with the Coastal Federation has been great in helping with obtaining easements, but at this phase, it's really just in the beginning stage. And we're moving forward with this, but we wouldn't expect any construction or anything like that to begin for at least another year. Additionally, update on the multi-use path. That is, planning staff will be working with the Public Works Department to develop the grant application as the multi-use path continues towards Hollowell Street. We hosted, the Dare County Arts Council and town staff and businesses hosted the Gallery Row Roll and Stroll. There was a nice turnout for that. something that we hope can continue. And the town manager asked that we forward on to you the official notice from FEMA regarding the community rating system, the CRS notice, where essentially we're retaining Air Class 6 designation, and residents will continue to receive that discount on their flood insurance. That's all I've got. Happy to answer any questions.
I have a question as it relates to the field stormwater and runoff segment. Did the legislature pass a bill prohibiting us from adopting anything more stringent than they do in the state level?
We got a report, we sent that and asked that very question of the attorneys. Maybe John can add more. Ben Gallup gave us a pretty detailed summary of that, and there is a moratorium that goes into effect on through October 2014, but we are, if we're able to prove that the regulations are necessary for public health, safety, and welfare issues, I believe we're able to prove, if we can prove that, then the ordinances will stand. John, is that correct?
That's my understanding as well.
All right. And only one more question briefly. As it relates to our grant program, I know I believe it's fiscal year 13-14 or fiscal year 14-15 that we've applied for grants from the Outer Bounds Visitors Bureau. Are we a year in advance? Are we going to be in fiscal year 14-15 for those grants?
Well, we will apply right now. The plan that the board approved with the budget was to make a grant application to the Tourism Board in September for the next phase of the multi-use path, which will be constructed in this fiscal year, but reimbursed in the following fiscal
Okay.
year.
I just want to make sure we don't have an opening that we could slip in and apply for some more money.
No, we had considered and talked about application for the boardwalk along Sound Front with Windmill Point. However, we know if we were to apply for that and receive that grant, we'd be asking for a extension as soon as we got it, because the permit process for that is going to be extenuous, I think. Because you've got CAMA, you got the Corps, it's not going to be simple. So we're only applying for the multi-use path.
Okay, thank you very much.
There's also going to be a change, I think, and I mentioned this to you before, all the applications this twice a year to do grants, so we need to keep on top of what grants, what category they are, and make sure we have the deadlines for those application dates changed in the staff.
Yes, ma'am.
If
Thank
the
you.
change is made, which I think the board is going to be looking at that this coming meeting next week or in September.
Angela will be sure and stay right on top of that. Thank you.
Thank you.
I do want to add a comment that the Roll and Stroll was a big success. Saw a lot more people out and around Gallery Row and people actually walking. It's impressive.
I went early. It didn't seem, and that's, I went right at 5 o'clock. I drove around and around and around. I did not scroll. I thought, well, I'm probably just too early, because I guess people getting off work and coming up from the beach or whatever. I'm glad to hear that worked out.
And I think it worked well for the local businesses in there. I mean, they got a little
I
increase in
think they're
business.
planning on something else.
I hope so. Thank you, Ms. Wyatt. Our next item is old business, consideration of a resolution authorizing modifications to the 2010 land use plan.
Good morning, Mayor and Commissioners. The planning board initially heard this amendment at their June 18th regular meeting. At that time, they decided to table the amendment in order to give themselves time to review some added attorney comments. They had a special meeting on June 26th, and at that time, they made a motion to forward the amendment to the Board of Commissioners with revisions that they had made. The Board of Commissioners held a public hearing on the proposed amendment on July 17th, and at that time, you decided to wait to vote on the amendment to consider some additional comments from the Division of Coastal Management and the town attorney, and you were going to vote on the amendment today. The amendment you have in your package does include planning board comments, DCM comments, and town attorney comments. So you have everybody's comments right in that amendment. And I can answer any questions. Marvin Demers is here. He can speak for the planning board. And Charlotte Owens, the DCM district planner, is also here. And she can answer any questions you may have.
John, would you like to, do you have any comments on this?
The only comments I have are that the staff and the planning board and the town attorneys, primarily Ben Gallup, but me to some extent, have put extensive work into this language, and we feel comfortable that this is an appropriate set of revisions to the town's land use plan.
Questions for Ms. Welch?
Well, I don't have a question, but there was a comment earlier on that it's definitions and meanings for the ocean, beach, being on watermark, static vegetation line, and the ocean as an area of environmental concern. Over the time, since this discussion has been ongoing since our last meeting, I've had a number of people, several, ask me for definitions, and I like the expert, our attorney, if you would, or perhaps Marvin G. I'd like for the public to hear the definitions of each one of those terms that we have time.
Yes, ma'am.
So you can bring these up now. Which terms and specifically?
Go up to the planning board recommendation,
Uh-huh.
and the first, go over there, over that up.
Farther up.
I will tell you, I think a guy wearing a robe is probably the final definer of these.
Well, we always know can change in front of the judge, but as far as a layman's being able to explain this to his neighbor, what the ocean beach is, can you find it yet?
Yeah, Ocean Beach, okay.
Okay. It just would help clarify some of my neighbors.
Well, these are, first of all, the term Ocean Beach is a well-defined term. I'll talk about that one and the mean high water mark in general, but it's pretty well stated in here in terms of the Ocean Beach. The Ocean Beach area is defined by North Carolina General Statute 77-20, and it includes the areas that are adjacent to the ocean that are subject to public trust rights. It's basically the area of the beach that is sometimes covered by water. So if you think about it in physical terms, basically from the toe of the dune line or the vegetation line seaward, that whole area is what constitutes the ocean beach. The statute is kind of confusing in that it says that this area is defined, or the boundaries of it are marked by three different things, which could be in different places in different locations of the beach. And that's what makes it a little bit difficult to specifically identify one area from the next. But basically, the toe of the dune, or the storm trash line, or the first line of stable natural vegetation are those indicators of where the landward extent of the ocean beaches are. Typically, I think most people would say, well, whichever one of those is the farthest landward probably is the area that has been covered by water at some point in recent past. So that's basically how the ocean beach is defined. It's one of those things, I've said this before, but it's one of those things, you know it when you see it, basically. The mean high water mark is a little bit more limited idea. The mean high water mark is basically the area, it's an elevation. Most of the time, at least for survey purposes, a surveyor will determine that area based on using a tidal, T-A-D-A-L, data set of an average mean high tide over a 19-year average. There's some question as to whether a court, if it had to define exactly what the mean high water mark is, would use that title datum, or would use the average tides in an area over some particular period of time. That part has not been real well defined. There's some cases going both ways on that particular item. The vegetation line, again, you can, there's a CAMA regulation that defines the vegetation line with some precision. That's basically, though, the line where natural vegetation has naturally taken root and has held up for some period of time to become established, and the seaward extent of that vegetation area is the vegetation line. And then what were the other terms?
The ocean hazard area.
The ocean hazard area is a CAMA-defined term, defined by CAMA regulations. It is basically it encompasses the ocean beach in general. There are various regulations that work, or that set forth some limitations on development in that area. There are some setbacks included in that area, but basically the ocean hazard area is that area that we would think of as the ocean beach, as well as the fragile areas of the dune and so forth. So, but I'm glad you asked that, because the point here is that the town, in developing these amendments to the land use plan, have been very careful about using what are the generally accepted and legally supported definitions of these terms, not necessarily the terms that lay people might use, and we've tried to do it in a way that it has the most precision available. You know, we've referred to the dry sand beach and the wet sand beach. Those terms are a little bit more vague and not as precise and not as helpful, although if we say that the ocean beach includes both the dry sand beach and the wet sand beach, whatever they are, it pretty much defines the entire ocean beach.
Thank you.
Yes, ma'am.
Other comments, questions? I did have one question on ocean access, and item D, the town shall continue to require non-oceanfront hotels and motels to provide private oceanfront beach access facilities. Is that new language? It's in red, but we've had that in there before, correct?
That was in there. That's correct. I'm sorry, what part is that?
We deleted that.
Do you know?
I thought we did too.
What had happened is we had inadvertently taken it out, and it was caught by the district planner.
We didn't inadvertently
I think it
take
wasn't
out.
inadvertent.
The board voted.
It's currently in the land use plan,
Well,
in the 2010 plan.
I agree with them. I think we took that out last year.
Well, we may have voted to take it off our ordinance, but not add the land use plan.
Okay, yeah,
We
it's
took
still
it out of our
currently in the
ordinance.
land use plan.
Okay.
If you want to take it out of here, I think we can talk to the DCM planner to make sure it's not a change, a drastic change, I'm sorry, a substantial change to it. But if that's something you want to look into.
I mean, is that
Yeah.
the will of the board to do that, I guess would be my first question. And we are, I think you're correct. I think we did it in the ordinance fashion
I
already.
think Angela could just check, make sure with Elizabeth, that we did take it out, and then this is where it's not correct. If
Well,
we select,
we didn't take it out of the land use plan. That's what,
but shouldn't we?
the question is, do we want to, we're doing these amendments to meet a deadline. If we start making a lot of changes to it, we're not going to meet the deadline.
Yeah, that's right.
If DCM
That's correct.
thinks it's a substantial change from what they got from us in June, then we wouldn't be able to move forward in September with the meeting.
We're getting a head nod in the audience on that, too.
Yeah,
So I guess is the head nod that this is a substantial
Can-
change or
Charlotte,
not a
can you come up
substantial
here?
change?
We'll let Charlotte take care of that one.
We can always amend that later.
I would say yes, it is a substantial change because your advertisement was specific to the sandbags and the septic systems. But you can certainly go back through a process and amend further.
Thank you, ma'am. I think hearing that, we're better off leaving it in and can go back and modify in the future, but I think we should put that on our list because we want our ordinances to match up with the land use plan. With all that, I'll make a motion to approve the modifications.
Second?
We have a motion and a second. Is there further discussion? All those in favor of the motion signify by saying aye. Aye. All those opposed, like sign. Motion passes unanimously. Our next item is H2, appointment to the Albemarle Regional Planning Commission. Now, this is a highly prestigious post.
Yeah.
And our NCDOT representative actually says that these regional planning organizations are going to be much more important in the future. So I am asking y'all to find a replacement for me. And I'm looking for volunteers.
Well,
But I'm willing to draft people.
well, you know, I know that you'd be surprised when I tell you this, but there'll be, there could possibly be, 3 different people in this 40-day December. So if you appoint someone today to serve a 2-year term, what is the remainder of your term? Is that how that would go, Bob?
I haven't seen an expiration date on it. I think you're there till you...
Which was why he's acting now.
You mean you don't have to run for this position, Bob?
No, ma'am, you don't.
So my concern is this, you know, we know that Renee and Susie will be here for at least 2 more years. We may not, Doug, you and me and Bob.
And I definitely will not.
One of us may not be here either, or both of us might be gone. So my thinking is that we need to draft Susie or Renee, and then if sometime in the future they need to remove themselves from that board, they can always ask. Not will they be given, but they can always ask to be.
How frequently do they meet?
I believe it's quarterly.
4 times. I think it's 4 times a year.
Quarterly, unless we're up, in the spring, we usually do a couple more meetings,
When's the next meeting?
prioritizing
September 18th. Is that right? Next meeting? Tentatively September 18th.
We were holding off because of the changes in the funding formula with the state. We're trying to get more information on how that's
And
actually
we do
gonna
get
work.
excellent staff support at these meetings.
So are you saying you don't want to go in September, is that what it is?
Yes, sir.
All right, well, I mean, I'll go in your stead in September, but I think we should wait till after the election, appoint somebody.
Okay. I'm not seeing anybody raise their hand other than that, Doug. Thank you very much for volunteering.
Yeah. That's a good idea. Since they'll be meeting in September, do you know where, Angela?
The meeting in September is going to be in Hertford,
That's what I thought.
Performance County.
They're always, they're
I
generally
was
in
going to say,
Hertford.
when I was on the Albemarle Commission, it was always in Hertford.
Always in Hertford.
Well,
And if I could, we do, Elizabeth Teague was appointed as his backup if he couldn't, if the mayor couldn't go. So if you wanted to continue on with that.
I think
Or-
that's a very good arrangement, actually.
And I'm actually at both meetings because I'm the chairperson of the RT, the first meeting, so.
We'll blame her if we don't get money.
I'd say we have good representation in Angela already, so.
I would
That gets
agree.
me off the hook, thank you.
Well, I think what Representative Fearon was trying to point out was you got to be at the table, meaning the elected body better be at the table because it'll matter for the funding. So my recommendation is we don't want to miss out on anything.
I'll be there.
And
Now,
we'll-
can we formally appoint you to this, Mayor Pro Tem?
Like Anna said, we might not be here.
well, why don't we think about appointing Doug? And then if he doesn't return, we'll appoint somebody else in January.
Well, I mean, what I was saying was, I mean, if the mayor wants.
You're saying
the mayor
you're
wants to get out-
substitute for
When the mayor
me.
wants to get out, I'm substitute for him as the mayor pro tem, go to the meeting, and then wait until after November and appoint somebody else, because September, October, November, December, January is the next meeting, or February.
Mayor, do you have to
So,
Yes, I thought so too, because I remember that while with Doug being on it. I think we need to appoint Doug.
I'm fine with that.
Good.
of course you
I
are.
nominate Doug to the Albemarle.
Second, further discussion? All those in favor signify by saying aye. Aye. All those opposed, like sign.
Thump, thump.
Angela, remind me, will you? Call me and remind me, we'll go, you know, you can ride with me.
Thank you, Mayor Pro Tem. Item number 3, consideration of a memorandum of agreement between the town and Nags Head Elementary School for the school resource officer position.
Mayor, we sent this, as you know, to the, obviously to the school board and their attorney to vet it and go through it. There was really no change other than the superintendent obviously would want to be notified if there was a dispute prior to, you know, I'm sure our officer is going to notify the police chief first, and likewise the superintendent would expect the same from the principal of the school. And I believe the other, there's a section on the last page about staff interviews that was added, that before any staff members are notified or interviewed, the officer should notify the school principal prior to. Other than that, I think both sides are ready for your approval.
And this begins, I think, Commissioner Cahoon had mentioned about the time, it will begin with the January 1st.
Correct. Right. We'll continue to be present, but not under this agreement until that school resource or the Nags Head police officer is appointed to the school.
And then I have another clarification. Now, Cliff, this person's job with the school ends with the school year.
Correct.
Okay, and
What, their appointment will then be on the beach.
Right.
Yes, ma'am.
Does this person take the current person's job?
Right now, we have somebody that's on the beach on a part-time hourly basis. This will take the place of that position.
So, again, for clarification, will he become a police officer on the beach rather than a?
Ambassador or educator, yes, ma'am.
All right, thank you.
Any other questions on the memorandum of agreement? Entertain a motion?
I'll make a motion to approve it as submitted.
Second.
We have a motion, we have a second. Is there further discussion? All those in favor signify by saying aye.
Aye.
Aye. All those opposed, like sign. The motion passes unanimously. Our next item is a discussion of water consumption unit refunds. Mr. Leidy?
thank you, Mr. Mayor. We've looked at this issue, sort of revisited and updated the work that was done on this in 2005 by planning staff and Ike McCree, but and I have various opinions and observations about the water consumption units issue to provide to the board at this time. Basically, I think it's clear that the town does have authority to redeem water consumption units that have been prepaid and are being held by Ammons Dairy Corporation. In fact, the 1987 agreement between the town and Ammons Dairy Corporation says that the town will do so. Now, that's the easy answer. It gets a little bit more complicated from there. Although Ammons Dairy Corporation has been dissolved, it might still have the authority to transact business as necessary to wind up its affairs. Even a dissolved corporation has that limited continuing authority. So Ammons Dairy might still have the authority to convey back to the town any of the prepaid water consumption units that it still owns as part of winding up its affairs. The town has a legal obligation to redeem those from Ammons Dairy, but there is no timetable or schedule for the town to do that. Under the town's agreement with Ammons Dairy, the only time constraints that were provided was that the redemption would not occur until after the reverse osmosis plant was constructed, which occurred in the 90s, and then it would happen as funds became available. The town has a great deal of discretion as to when those funds are actually available, so there's really no timetable that the town has to work under to make that redemption. Now, the town adopted an ordinance in 1990, and after these water consumption units were credited to Ammons Dare, and the ordinance provided a lot more details on this redemption issue. Basically, it provided that prepaid unused water impact fees would be refunded if surplus funds become available for such a purpose. But still, the town did not commit to any particular time frame for the refunds at that time. The 1990 ordinance also imposed several conditions and limitations on the town's ability to refund these. Basically, there are numerous conditions that someone has to meet in order to qualify for a refund. Since these conditions and qualifications were imposed after the initial transfer of water consumption units to Ammons Dare, they probably don't apply to any that are held by Ammons Dare Corporation at this time, but as to those that have been transferred to others, they might actually apply and govern those. So the town still has the authority to redeem unused prepaid WCUs that are owned by other people who've received a transfer from Ammons Dare, but they may be subject to those limitations. All right, so the authority is there, the obligation is there, but there's no particular time frame within which the town has to act. As was discussed in 2005, there are some concerns about how people might prove their right to a WCU, and concerns about the town making mistaken refund payments. At that time, it was recommended that the town try to get an agreement from Ammons Dare to actually receive the monies and to process the refunds, and the corporation didn't want to do that at that time. So the town took an alternative route, which was giving notice that a redemption program was going on, giving people an opportunity to come forward, to demonstrate their ownership, and then to allow for the redemption at that time. Our recommendation remains that the town do one of those two things if it wants to redeem these WCUs, or whenever it's going to redeem the WCUs. Basically, if you require that Ammons Dare participate in the process in some way, then to the extent it has any rights in those rights will be eliminated by the actual refund and by their participation in that. Otherwise, in not having them involved in the transaction leads to some risk that the town might pay for something from somebody who doesn't really own it. And not because they're being dishonest, it's just because the actual trail or chain of custody of those might be somewhat unclear. There's another alternative, again, to the extent the town wants to move forward with this process. Another thing that could be done is for the town to file what we call an interpleader action. That's a lawsuit where someone who has money or property files a lawsuit, offers the money to the court and says, we owe this money to someone, we're not really sure who, we want you to figure it out. Basically, that's what an interpleader action is. The benefit to doing that is that if the court acted then under and pursuant to a court order, then it would be clear that the town would be satisfying any obligations that it has. And again, the final alternative beyond that would be, instead of the town taking that initiative and being proactive, it would be waiting for someone else to come forward and to demand a refund. And then again, to the extent that that would be done through a legal process, the town would be held harmless by making redemption pursuant to a court order. So, and then the final option, town could do nothing at this point and wait until a later date when it might determine that it does have, in fact, surplus funds and really wants to go forward with the refund or redemption process at that time.
John, is there an obligation to pay a third party on this? I understand the obligation for Ammons Dare, but is there an obligation for the town?
The ordinance does provide that anyone who holds one of these, who has a prepaid water consumption unit, and let's talk about someone other than Ammons Dare, that the town will refund those if certain conditions are met. And the conditions are very restrictive. I mean, among other things, it must be, the property must meet certain requirements. It must be a single or two-family residence. It must be located on a 40,000 square foot parcel. There's some other requirements that must be met. I don't know how many lots are really going to qualify and meet the terms of what the town says it would redeem from others. And I'm using the term redemption instead of refund for an important reason. The agreement with Ammons Dare talks about refunding prepaid units as if they're no longer needed. And that might or might not be the case. My opinion is, and I think everyone's opinion who's looked at this has been, the WCUs retain a value. They can still be used, they can still be applied as credits for redevelopment or other types of development on certain properties. So I don't think it's really a matter of a refund, as if someone's overpaid for something that they can't use. I call it a redemption because it's the town actually paying to get back something that somebody holds that has a value. So I think these WCUs do have a value. I think they have a value in the hands of Ammons Dare, or they have a value in the hands of a landowner who might still be able to use them for redevelopment or a change in use of their property. But as far as an obligation, yeah, the town has an obligation to refund them, but under no timeline, and only when it decides that it has surplus funds available for that purpose.
So we've got a specific request in front of us. Has that specific request met these criteria?
That part I don't know. I don't know if that property meets these terms. All I can say, because I haven't looked at the actual physical request that you've received, except to say, since it's not coming from Ammons Dare, they would have to meet these specific requirements that are set forth in, let me just recite what those are. And I have real questions as to whether any property is going to really qualify, to be honest with you. There may be some, but there are not going to be many of them. Property must meet the terms of, or the requirements of Section 44-63 of the Town Code, and I'll get to those in a minute. In addition to that, the board must determine that due to unique environmental conditions particular to this particular property and surrounding property, that the benefits of preserving the environment outweigh the advantages of installing a water distribution system to serve that property. And based on the most recent update of the town's water distribution needs, there are no plans to extend and no reasonable expectation to service the property in question. All right, that's the first set of requirements. The second set come from, let's see if we can find that, copy of that statute. Just look right at 4463.
Good thing he brings that big book with him.
Okay. To meet the requirements of, or the conditions of Town Code Section 4463, the property must have a structure located, the property must be 40,000 square feet in size, or an existing lot of record that does not front on a dedicated right-of-way, or a lot that has been previously developed without the benefit of a water tap. It must be located in excess of 500 feet from an existing installed water main that has been accepted and maintained by the town. The lot must be recorded at the county registry and meet all subdivision and zoning requirements at the time of its creation. The developer must obtain all necessary approvals from the appropriate regulatory agencies, and there must be a fire protection method available that meets the town standards. So the lot size and the location issues, I think, are going to limit the number of lots that will actually qualify for that. But I haven't been asked to review any specific request other than to say that these are the...
Well, John, I'm sorry, but there's been a specific request in front of us, and that was I think that was the charge, is whether we can do this or not.
Well, I mean, that's, well...
Go back to
So
the...
let's ask the attorney to do exactly that.
Yeah, well, again, the question is, assume that it meets those requirements, does the town want to do it? I mean, I guess if the question is determine whether this particular property is going to qualify for the redemption or not, then you can make a decision. But I don't know if the board really wants to do that or not. That's the issue that I have. Because if you do, then the question is, okay, what process are you going to go through? Are you going to require them to present a chain of title, a certificate of title from an attorney, which is what I'd recommend to make sure that we know that someone else has come forward with this proof that they're entitled to the refund.
Commissioner Green?
No, Susie was first.
It seems to me that we really don't have enough information to make the decision today, and I would like to know what properties actually qualify within the town. And I think we need to develop a process if we are going to do this, including a timeline. And then also I have a question as to the interpleader process? What are the costs associated with that process? Estimate.
Probably, my ballpark estimate, somewhere in the neighborhood of $20,000 to $30,000, something like that.
And the other issue with that, Susie, is that we take that amount of money and give it to the court to distribute, and it just sits there. If nobody-
That's correct. That's exactly
And
right.
That's not the way to do it, yeah.
John, go, sorry. Go
I have
ahead.
a question, John. You've talked about the property. If the person no longer owns the property in question, then they're no
Well,
longer a property owner.
as far as the WCUs issued to Ammons Dare go,
Right.
those were not tied to specific properties.
I understand that.
Those that other people have retained do run with the land, so you have to be able to demonstrate that you still have these properties in order to demonstrate that you have the right to a refund for the WCU.
That was where my question was going. Okay.
I just have a suggestion, if everybody would, and I hope we all weigh in on this. Susie said the word a while ago, criteria. I'd like to see our attorney draw up criteria for anyone that is holding a WCU. And if they can meet that criteria, I would like for the town to start cleaning this money off the books. If they are qualified to receive a refund, then so be it. This has been going on since before I came on this board, and I hate to just leave something so cloudy on the board for future people. You may not have the history that these past boards have had with these WCUs. If the money is owed, I understand we really have no set legal obligation. If someone can do that chain and prove that they are not using it, they have the right, they hold this list, then redeem, then allow them to redeem the money. That's my suggestion. And I do not agree with giving money to the court. Doug's absolutely right. It'll sit there and on their line item.
Yeah, I might be putting in for it.
I don't believe the attorney has the authority, though, to draw up criteria that would be in conflict with the ordinance. If evidently there was an ordinance adopted in 1990, which was even before me, as long as I've been here. But
That would
he
be in
can't.
conflict with the
Yes, he
ordinance.
can't draw up criteria that would be in conflict with an ordinance that tells you what to do.
Yeah, what we could do, I mean, what I think you're talking about is really going back to and reestablishing the process that the town previously
Right.
instituted and then tabled after y'all had commenced it in 2005. I mean, that's, again, that's one of your options. Again, there's going to be some work required with that because we have to get folks to provide us with, certification of, or I would say the town would want them to provide a certification of their right to the WCUs.
Mayor, I'm sorry, please.
No,
No.
I was just going to ask Cliff a question. Can we ask staff to come up with a matrix of the properties and the criteria required by the ordinances that must be met? So that basically you can check the blocks for each property and then go from there to develop the process by,
Can do that.
which we would, based on past documents, so that we're doing everything we're supposed to do and, with the assistance of John in that
And
process.
And am I hearing that we go back to public notice and advertise that we're putting out a call for reimbursement?
I didn't hear that.
Okay.
No.
Well, let
I
me.
think you're jumping ahead.
Okay.
Let me interrupt you for a second,
Okay, go.
Counselor. At the last meeting, when we brought this up, all of us agreed to find out, to ask John, whether or not we had an obligation to these people. I'm not hearing the same thing Anna's hearing. I'm hearing we do have an obligation. So if we have an obligation, we need to find out exactly what that obligation is and to who. And that's what we need to do. So how we go about that is, I don't know if we do it by the manager or the planning staff or whether the attorney. I thought it was an attorney situation myself. I thought that to research it and find out whether or not the individual corporation or whoever that has requested the refund is entitled to it. That's all I want to know about. I don't want to know about anybody else. If you want to start a process, that's fine too. But this is the obligation I think we have right now, is to make a determination about whether or not the person that has required or requested that, you'll call it a refund, what do you call it? Redemption
Yeah.
is qualified for it. And how we achieve that, Counselor, is, I mean, whatever your recommendation is.
Well, I think first of all, we can do that. We can determine, and I misunderstood my charge, I'm sorry for that, but we can certainly determine whether these folks qualify or whether they have a colorable claim that we feel they should provide further proof on. That can be done. I think that's an appropriate way to proceed. I'm concerned about the cost that would be involved in trying to determine who else might qualify. It would be similar to doing, in fact, probably to a degree, would require a title search on a large number of properties, many of which would not qualify, which is why I think it's easier really to determine. I mean, I think we know what the potential number of WCUs the town may have to redeem are, 93, I guess. But I think it's easier to judge them on a case-by-case basis using a protocol. I feel like that would be more cost-effective for the town. It would avoid some of the work that would have to be done as a component of actually filing the interpleader action. We'd have to. That's one reason why there'd be a lot of cost involved, but that would be some of that type of cost. But I'll do whatever the board wants.
We've had a specific request on water consumption unit redemptions. I think the board would like you to look at that specific request and see if it meets the criteria from the ordinance and give us advice on how we can do it. I don't think we want to incur a huge amount of cost, and I also don't think that Ammons Dare has had an opportunity to ask for redemption, and they chose not to do so.
Absolutely
I
right.
think that one's out of that's not going to come back to us. So I'd like to see on this particular
It might if we
request some
advertise it.
comments. Yeah.
And actually, the history that I can give is when Ammons Dare did ask, back in the 90s, we did refund at the time, based on our ability to do it. We did refund money.
And I think if this was
Based on
Ammons
their-
Dare making this request, I don't think we'd be having this discussion, really. I think we all see a clear obligation there. Ma'am?
Susan has something that I have. Did you have something?
Well, I mean, if we're not able to identify who holds these through a relatively simple process, I mean, I think this is going to set the precedent for what happens forward, so we just keep revisiting it through this manner, just individual response as opposed to an overall, this is what we're going to do, I mean, and treat everybody exactly the same, or just leave the burden to individuals to burden perhaps the process to individuals to come forward, and we will just go through this on an individual basis? Is that what you're
It's such a
suggesting?
limited group. They're not, I don't think you will see any other entities come forward and ask for a redemption of these, because there are not any out there. The ones that were held, Ammons Dare has indicated that they're not interested in redeeming them.
Okay.
And then you've got a separate third-party group that has asked for redemption of a number that they acquired in a land transaction, but then didn't use completely.
And what I was going to say, I feel that both the burden of proof and the expense does fall on the applicant. As far as I'm concerned, if it is our obligation, we can make that determination at the time that, as you said, we have an applicant that's come forward. I'm not sure that applicant has done all of its due diligence to prove that they indeed qualify, but if they do, then I think that it is in order for us to consider their request very seriously.
And I think they would be able to prove a chain of title on these. I mean, it's fairly straightforward.
And that they have not used
Yeah.
and won't be using.
Well, they won't be if they redeem them.
And
But that's the thing. Yeah.
We're not going to get money back.
They could always buy a new water consumption unit at a higher price, but
That's right.
And that's another point we need to consider is we're redeeming them at $2,000 apiece.
Right.
We'd be reselling them at $3,000 apiece.
That's right. That's a fact of life.
I have no idea who does and does not hold these credits.
The majority of them were left with Ammons Dare Corporation. They prepaid them and just never redeemed them.
yeah.
And then through the RTC process, some of that land that they held was transferred with water credit units to other entities. And my understanding is all that land has been sold to another party. And they got the water units that they needed at that time, but these were just leftovers to a certain extent.
Well, what I'm going to propose to the town, and I'll be glad to do the investigation, but I think the starting point is going to be requiring that the owners provide a certificate of title provided by an attorney to the WCUs, and that's going to require them to have a title search done and present us with the information for us to double check. But I think that's really the safest thing to do. Maybe some of the procedural steps that we'll recommend following that, but I think that's really the way to go.
And I think I'd like to see that, and then some assurance from you that we are legally able to do this, that we're not breaking any of our own ordinances. Everybody okay with that?
Absolutely.
Well, we'll talk about water credit units again then.
We will.
Probably a few times.
And I apologize, John, I'm not so sure that that was just that's what I remember. I might have been unclear on, because I remember bringing it up, but whatever.
No problem.
Next item is committee reports. Mayor Pro Tem, any committee reports?
We don't have anything, no, sir. And I don't have a thing, Mayor.
Sir. Mr. Wiltz?
Well, I attended the Jeanette's Peer Advisory Committee along with Cliff. However, I forgot to bring my notes with me today. But from memory, we elected a new chair, Ken Wells, and a vice chair, Ray White. We amended the bylaws due to some changes within the aquarium regarding who participates and who doesn't. And then we have some issues that are kind of in flux regarding who will actually sit on that committee because of clean water management, things that are just up in the air. And I'll leave it to Cliff to add any other comments.
The only thing I'd add is it's pretty clear now that the three aquariums and Jeanette's Pier are on the same line, organizational chart, I guess. But we talked about the budget and the fact that the aquariums were given a year in this year's budget to come up with funding revenue sources to offset some of the cost. Jeanette's Pier was not included in that. And I think there's also some reworking with the Aquarium Society agreement. The return on the retail sales from the Aquarium Society was about 7 or 8%, which is kind of low compared to the three aquariums. So they're looking, even though they're not been charged by the General Assembly to come up with additional revenue sources, they are looking at all avenues.
And their return is low because of personnel, staffing.
Overhead.
Way too many.
Overhead. Well, they're open for a longer period of time, and there's an associated cost with that. So I think they're analyzing their process.
The other thing was, it was Damon Tatum's last meeting. He was on his way to Florida. I think he had the car running during the meeting.
Looking back.
No, I don't think.
Thank you. Can I get clarification? I think something you said. Did you say that the three aquariums are looking at how they can increase their income, but Jeanette's Pier is excluded?
Well, I think they just weren't part of the concern of the General Assembly, the public-private P3 partnership. The Jeanette's Pier hadn't been included as part of that discussion, but the three aquariums have. I mean, that was a charge in this year's budget going forward, was to come up with a plan for generating more revenue. But Jeanette's Pier is also doing the same by looking at the Aquarium Society's return.
Well, I'm really surprised because Jeanette's Pier could do a lot to increase their revenue if those folks in Raleigh would allow them to charge like the other piers do, which is a walk-on fee. I mean, that's a lot of money they're missing.
That's right.
And if money is needed, it's so clear to so many people out there on the street that that's a great way of getting revenue. And that's been pushed for years, and I've sat on that. Susan, person here.
We haven't had a committee, but to give you an update on the Coastal Resources Commission, the legislature did pass a bill that revamped it. They reduced the attendance number of members from 15 to 13. Only 2 people out of the 13 have to be residents of North Carolina. The other seats typically could theoretically be out-of-state people. They did, of the current members, they kept 4 out of the
Congratulations for
oncoming
making
13.
the cut, by the way.
Made the cut. The chairman made the
That's a
cut. Lee Wins from Coleraine, who also owns a house in Nags Head, made the cut. And then Jamin Simmons from Fairfield made the cut. 2 new members have been appointed already. One is Mayor Harry Simmons of Caswell Beach, and the other is Mark Hairston, I believe, from Onslow County. He fills the wildlife seat. All the rest of the seats are vacant, which means that there's only 6 out of the 13. So whether they get appointed before our September meeting, if they don't, I guess we won't have a September
Be
meeting.
nice to at least get a quorum.
True. That's right. So that's the update on that. And the appointments no longer resides strictly with the governor. The governor has appointments. He's the one that made the Harry Simmons appointment. The Speaker of the House has some appointments, and the President Pro Tem of the Senate has some appointments. So that's where it lies right now.
Thank you, ma'am. Best of luck there. Commissioner Sadler?
The tourism board actually did not have a July meeting. However, saying that, I've met twice with other committees, subcommittees, one being the grants committee. And for the first time, you can remember in a long time, we had 11 special project grant requests to come in. We had a pot of money that totaled $68,000 and I believe, or $78,000, and I believe the total request of those 11 grants were $168,000. It was a long day. I'm happy to say that at this point, and this will go to the full board next week, that the grants committee was able to put some money in every request. That being said, I know Nags Head had a request for the Joy of It Christmas grant, and so there is some money we are hoping. The other thing that we're doing, and we were presented with 3 alternatives, this will go to the full board. The group of, is it VHB, I think they are, is the group that did Ducks Amphitheater and all of the improvements out in your area in Duck that has worked so successful. They are the ones that the tourism board hired to work on the events site. And they have presented to the steering committee 3 alternatives. This is just in the beginning phase, but I'm really excited about those. And it's really open air. They're big buildings. So the full board will be looking at that next meeting of the public. And press will come. It's, they've done a great job. It's going to be hard to make a determination. Of course, it'll all have to be phased because of the money that is available to, to develop the site. That being said, that's all I have for.
Yes, ma'am. Thank you. We did have a very brief Colony Ridge Committee meeting. They had an internal audit, I guess, was from somebody from their corporate headquarters was down. They arrived the afternoon before, so the director was unable to meet with us. She vice president?
Lisa?
Lisa?
I think so, yes, sir.
The vice president was unable to meet with us on the TV screen. It was Robert Gray, myself, and Cliff. We didn't get a whole lot accomplished, but we're really just waiting. And we had their modifications on our agenda for today, but they apparently didn't communicate back with their engineer to give them direction. So it's a little bit of a slowdown. We're not quite sure why. It's been, we're coming up on the 2-year mark from when the town signed the lease. And when we had our discussion, we talked about an 18-month time limit. That was not written specifically into the lease, but I don't understand the delay, to be honest with you. And I have expressed that disappointment to Mr. Uzel, and hopefully they will make some decisions and get moving. But right now, they didn't make this agenda because they didn't communicate back with their engineer to give them direction. So, a little bit of a frustrating meeting, but that's the way some of them go. Anything else on committee reports, y'all? We're going to go back to number 10, our consideration of traffic control amendment, no parking towaway zone. Chief Brinkley, will you?
Thank you, Mayor. As Mr. Oliver brought up earlier, the police department had received some concerns that had been expressed regarding a possible traffic safety issue down in the area of just south of Fire Station 21. If you look at the picture here, that picture is taken from an access road coming off of South Creek Acres, trying to get onto Old Oregon Inlet Road. This picture is looking south, so if you're a motorist coming out of South Creek Acres looking to turn onto Old Oregon Inlet Road, you can notice that there's a line of sight issue with the cars lining the road. We went down and we've looked at this site over a number of days, and the parking that's there's a very popular beach access. The mayor and I were out there yesterday to see the people coming and going. This is not a pier problem. This is a beach access. It's a beautiful beach there. People want to go. So when this has been identified, we're just trying to put some measures in that will make the area a little safer. Being there on site, what I would propose, and my recommendation would be a no parking area, no parking zone from the road that we're at now, looking, if you're here in your car, looking south. The distance to the speed limit sign is approximately 80 feet. And if you did that distance on either side, both south on Old Oregon Inlet Road, which you're looking at now, and then back north on the west side, I would like, and I think it would certainly help. I'd like to start out with something like that to see what help that would give us. And I think if you create that little bit of space, I think it will go a long ways in making the area a little safer. So my recommendation would be that there would just be no parking approximately 80, 90 feet down on the west side of Oregon Inlet Road, both south and north.
So I'm going to say 80 feet, Chief, if that's all right.
Yes, sir.
Because that's basically 4 parking spaces.
Yes, sir. It was 80 feet from where we're at to the speed limit sign, so that's perfect. 80 feet would be good.
Comments, questions? Yes, ma'am.
I know we've got a couple of emails from other folks in the area, some saying there were problems, some saying there weren't. But one thing throughout the ones I read was a suggestion, and I want to ask you about this, of perhaps pushing that 45-mile-an-hour speed limit even further south. Do you think that a slower speed, it is 35 there for a long way, and then you get to 45. Do you think at a slower speed beyond where people would park to go either to the pier or to that beach access? Do you think that might be beneficial? And the other thing that I want to say is I think it's past time for us to have a crossover, a pedestrian crossover, to get one side of the street to the other for the beach access. Since not only are people going to the beach, but they're also going to the pier. There's people actually park on the side of the road to walk over to the pier to fish because there's no parking available at the pier. So I'm just thinking that a crosswalk going to the beach access would be something that we could do or request you to allow us to do for more safety.
Yes, ma'am. Mr. Oliver, when we were meeting on site, yeah, he welcomes, everyone. He said he's got a beautiful beach there, and he doesn't, if people want to park in his parking lot and they go to the beach, he said, that's fine. So you've got a mix of people utilizing the pier, people going to the beach. You have the beach access that's right next door that will fill up very early in the morning, and then people begin parking along the shoulder of the road. Just south of here, where it does not create a line of sight issue, there's other cars that were parked on the shoulder of the road, which was from a rental cottage, or what appeared to me to be from a rental cottage. You remember years ago, we did increase the distance of the 35-mile-an-hour speed limit further south on Old Oregon Inlet Road. It was actually a suggestion by Mr. Oliver yesterday when the mayor and I were meeting with him. He asked that same question. Could that be a possibility? And I told him that we could certainly talk about that, and it would be a request that we'd have to make to the Department of Transportation. Your other question about the crosswalk, I think it's a very popular beach access with our beach nourishment and the wide beach. We could certainly tell that yesterday. It was a heavily used access, and we could certainly look at through Public Works and a request through DOT to have a crosswalk there.
Any other comments, questions? I will say it's nice to see the outpouring of public support for fish heads and the Outer Banks Pier.
Absolutely.
And it's one of those spots that kind of make Nags Head unique. I mean, you don't find that somewhere else. It's not something that every other beach town duplicates. So it is we do want to support those type of businesses, and we're glad for Mr. Oliver's success. But we also want to make sure that it's safe to pull out of the roads around there. So this would be amending the ordinance that we've got, and we probably, can we say 80 feet north of Isabella Street access and extending 80 feet south of the access? Is that
On the
suit
west,
everybody?
on the west shoulder.
On the west side?
Are you asking?
I'm asking to get it in writing, actually. And also, is this, that suit everybody? I think that suits everybody, but can that one be modified?
No, this one can't, it's a PDF.
Okay. But everybody comfortable with substituting 80 feet north and for 580 feet for 430?
80 in each slot.
Yes, ma'am.
Okay, yes.
Everybody okay with that?
Sure.
Well, I'll make a motion to that effect.
Second.
We have a motion and a second. Further discussion?
How will we give the chief directions for the other two items? Consideration of lowering the speed limit and crosswalk.
Consensus on requesting, because that's DOT, we'll have to request DOT on both of those issues, actually. I hear consensus to ask the chief to initiate that discussion. Is that acceptable? Further discussion? All those in favor of the motion signify by saying aye. Aye. All those opposed, like sign. Motion passes unanimously.
Thank you, Mayor.
Yes, sir. Thank you, Chief. Items referred to and presentations from the town attorney.
Thank you, Mr. Mayor. I'd like to update the town commissioners on the status of the sand soda litigation. We've had some good news in that recently. Let me first sort of go over the background of this to make sure everyone's on the same page about it. When this lawsuit was filed in 2010, the plaintiffs asserted two sets of claims. There was a set of state law claims, basically for inverse condemnation, for negligence, and for some declaratory judgments. There were also a set of federal claims, basically civil rights claims, contending that the town had violated the owner's constitutional rights arising under the Due Process Clause, the Equal Protection Clause, a civil rights claim based on alleged negligence, and a claim for a regulatory taking. Because of the existence of the federal law claims, we removed the case to federal court, where it's been litigated ever since. Judge Dever, several months ago, our trial judge, entered a summary judgment dismissing the federal claims, the federal constitutional claims, and as to the regulatory taking claim, he found that that claim was not ripe because the plaintiffs had not yet pursued and gotten gotten a decision on their inverse condemnation claim, which is a state law claim, and held that because that claim was unripe, it should be dismissed. He then sent back to state court all the remaining state law claims. The plaintiffs appealed from that decision, and 2 weeks ago, the Fourth Circuit Court of Appeals entered a decision which upheld the trial court's dismissal of the civil rights claims, which were the due process and equal protection claims. But as to the regulatory taking claim, the court found that the trial court had abused his discretion in dismissing that claim instead of either staying it or deciding it on its merits, or keeping that claim and all the other claims until the inverse condemnation claim was resolved. And so what the Fourth Circuit decided was that he needed to reconsider what to do with the regulatory taking claim. They didn't, and their opinion was very clear. They did not express any opinion on the merits of that claim. They simply said that the court should not have dismissed it, even though it was unripe. So what they've done is they've sent that claim back to the trial court and asked that he reconsider what to do with that particular claim. But the constitutional claims have been resolved. Those have been dismissed and remain dismissed. So we consider that to be a good result. At this point, not really sure what the court's going to do. Either party does have the right to petition the United States Supreme Court for further review, which seems very unlikely, but until that 90-day time frame passes, there's really nothing that can happen in the trial court that we expect to happen in the trial court. And at this point, we're not really sure what the trial court's going to do, whether he's going to request some further briefing from the parties or ask for what the parties want him to do with this remaining claim. That remains up in the air. But overall, we consider it to be a very good result, and we're very pleased with it. That's all that I have at this time. I would like to discuss the case and the Cherry case with the board in closed session in a little bit more detail at the appropriate time.
Thank you, sir. Mr. Manager?
Two things. One, the bill that Commissioner Cahoon referenced earlier, one thing I wanted to add to that is that it does require a unanimous vote. Any ordinance having to do with environmental, that vote would require a unanimous vote by the board in order for it to be enacted. The other thing is I regrettably was unable to attend the National Night Out last night. I was traveling back. I understand each one of the commissioners attended. Thank you very much. And I wanted the police chief just to come up and give a recap of a successful event.
Thank you, Cliff. It was a really good event. I know each one of y'all were able to attend, and I said last night I just certainly appreciate the board's support of the police department and the Nags Head Community Watch Association. You know, I told you a couple years ago that we were anxious about a change that I wanted to do for Community Watch and our National Night Out celebration. And this year's event was the second year that we had kind of changed things up a little bit. And I think you could tell from the turnout that it was certainly a success. We partnered with several of our local businesses and organizations, and the number of activities for our kids was just a really nice turnout. Had some raffles for the kids, some bicycles. We gave away raffled off some challenge coins the Community Watch Association did, and it was a really good time was had by everyone. And I again appreciate you for your support, and thank you for joining us last night. Thank you.
It's a great event, Kevin.
Thank you, sir.
That's all.
We ought to perhaps thank all of those people that partnered with the police department, Kevin. There were quite a few businesses.
I'm taking care of that this week. They'll be personally thanked and receive recognition for their support and joining us for the event.
I thank Mulligan's for the hamburgers.
Shannon and Gus were something I don't normally get a chance to see, is Gus standing over a grill. So that was quite a sight to see. We did get pictures, so we'll have to share those later on. But yes, it was, and I will make sure that proper recognition is made. Thank you.
Board of Commissioners agenda? Commissioner Sadler, will you start us off?
I will just say that I hope the audience will have patience with our planning and zoning department, particularly our zoning department. I understand that Kim Allen is laid up with a broken leg.
Yes, ma'am.
And that is not fun. So thanks to the staff for covering for him. Jim, hurry up and get back to work.
Yep. The staff is still looking out for Kim's responsibilities, so this isn't free season on code violations because Kim's laid up.
I know, but I'm just supposed to be patient when they call in and demand something that he's just not here.
Thank you.
And I want to also just say, what a glorious fireworks. I mean, it seems like to me we're kind of late thinking, and it's, you know, July 4th, and it's, it just seems like it was a year ago, but what a great evening. I hope they're there forever for us.
I had somebody say to me yesterday that they had never seen that many people on the beach, and I think that's probably correct.
Well, they'll see them hopefully next year. That's all I have.
Thank you, ma'am. Commissioner Cahoon?
I had heard what was referenced this morning in public comment as well by Margaret. And it occurred to me that as we plan our zoning and so forth, we take great pains to create different districts. And we created a recreational overlay district. And somehow I don't think that would be the site for any big box store. And I was happy to hear what Commissioner Sadler said about the Visitors Bureau vision for the event site. But I'd like to see us take a look at modifying our recreational overlay district to keep it the character that it currently has and not allow bigger structures. I'm not opposed to Tanger. They've been there before the recreational overlay district was created, and I think we ought to grandfather that in, but I don't think that any big box store, for those that aren't familiar with the recreational overlay district, it is the west side of 158 from Lakeside Drive around on through the causeway, and I don't think any large structure, box store, if you will, blocking that sound front and taken away from the recreational overlay district is the character that we envisioned. And I'd like to have staff bring back something and go through the planning board and bring back something that would address that issue as we move forward. And I would make that a motion to have the planning board and staff bring something back that would give us size regulations, height regulations, whatever. to bring that.
We have a motion and a second. Further discussion?
I think Renee, and I did have it, I think Renee simply nailed it. It's not that I'm not open for another business coming into town, but if you take that area, it's kind of like we've taken our commercial area through the years and allowed residential to build, and then pretty soon you're short on the commercial. When you take an overlay district that you have purposely, not you, but those who came before us, and made that area strictly for outdoor amusement. It's a district that a lot of towns don't have. Then to start putting in other development in that area and obscuring that sound view, I think we're going down the wrong path. And that is one of the things that the tourism board has been very careful about, was trying to develop something that still is at this stage, but allows events to happen, and giving it the minimum necessities, such as bathrooms, that it can house. So I'm glad you brought that up, and I hope staff can come up with something.
And even when there was the talk of a conference center or whatever there was a vision, even though it wasn't to fruition, was to have a building that you could see through from the road to the sound and not block the vistas that we have, because recreational businesses can't go up anywhere in town but in that district, and the vision was to keep a vista there.
Now, I hear what y'all are saying about the overlay district, but I believe that overlay district sits on top of a C2. Is that correct?
It does, but it's a very limited, it does sit on top of C2. You are correct, but I think we need to modify that much as we modified it when we created the overlay district. Because we did put in, it allows restaurants, it allows other things, but my vision is, I don't think we ever intended it to keep on allowing big boxes.
And I also think we've got an ordinance in place that prohibits boxes over 40,000 feet, I think it
40,000.
is.
That's still a pretty large door.
And we also have the height restrictions in place already too, right?
But, yes, we do, but 40,000 square feet is a lot to,
And do you want a 40,000 square foot box in the overlay district?
I mean, I want what's allowed by the ordinance. And I think,
and I'm asking
I
that we
think you've
take
got
a
a lot
look
of
at it.
restrictions on it already. I'm saying that that overlay ordinance did not mean that that whole district was just for outdoor entertainment. And obviously it's not, because you've got some other things in there.
But I think when we look at our C2, we have lots of areas within town that would be more amenable to box stores. You haven't heard me mention anything outside the overlay district. And I think that in the neighborhood that I live in, and we had a couple of people here this morning, including over a couple of businesses, that's not the character that they want to see in the overlay district, or anybody down there wants to see in the
Yeah.
overlay district.
And I don't disagree with you, Mayor, but my feeling on the thing is you're taking on a conglomerate that can, that has more money than most third world countries. So, just to clarify things, I mean, what we're asking is that the planning board come back with a, so, I mean, I don't disagree. I know that corporations like that have the ability to afford stuff that municipalities might not be able to afford.
I will make just a quick comment on Margaret's comment about grocery stores per head. Obviously, we have a lot of visitors in the summer, and I think that's what drives the grocery store business rather than the permanent population. Other comments? Discussion? Ma'am?
I mean, for the sake of discussion moving forward, I mean, I'll support seeing what comes forth.
Okay, we have a motion, we have a second. Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
All those opposed, like sign. Motion passes unanimously.
Thank you.
Yes, ma'am. Commissioner Walters? Mayor Pro Tem?
Not a thing, Mayor.
I have nothing on mine. We did have a request for a closed session from the attorney in accordance with GS 143-318.11A3. Did I get that right, John?
Yes, sir.
I'll make a motion for us to enter a closed session, brief closed session.
That's to discuss the sand soda litigation and the Cherry Inc. litigation, and to confer with the town attorney and preserve the attorney-client privilege.
Yes, sir. Second. We have a motion and a second. Further discussion? All those in favor signify by saying aye.
Aye.
All those opposed, like sign. Motion passes unanimously. We're recessing to a closed session. I think that's correct. We're going to come back into our open session after a brief closed session. I'll ask Mr. Leidy to report out from our closed session.
Thank you, Mr. Mayor. The board did confer with the town attorney regarding the Sand Soda and Cherry Inc. Cases, but no action was taken.
Thank you, sir. No further business come before the board at this meeting. We are going to recess to a Board of Commissioners NCDOT workshop on Wednesday, August the 21st at 3 p.m. And the main discussion there will be Little Bridge, correct?
Correct.
Okay. Well, that said, we're going to stand in recess until Wednesday, August the 21st at 3.